protest is a challenge to the agency solicitation, such as the requirements or the evaluation criteria, or could also be a challenge to the actual technical evaluation or the award decision. The protester is challenging, alleging that there's a violation of law, regulation, or that there's an abuse of discretion where the agency did something that was unreasonable. There's typically two types of protests, either a pre-award or a post-award protest. There are 4 different types of protests or forums that a protester could go to. First, they can go to the Small Business Administration, the SBA. They want to challenge the NAICS code that we've chosen, or if they are also doing a challenge that a company, especially on the small business, set aside that the company is not a small business, so a size protest. Also, you could file with the agency, whether by a letter or an email to the contracting officer, and basically alleging some type of violation that has occurred. The third way is to file with the GAO. They have an electronic filing system, and they would file their protest there, whether a pre-award or post-award, with the GAO. The fourth avenue is to go to the Court of Federal Claims, a true court versus the other ones that are more administrative bodies, and filing there. As far as the timeliness, though, for an agency protest, you'd have to file with that. If it's a pre-award, you have to file before the solicitation is due date. Or again, if it's the competitive range decision, once you're notified of that. Any other protest is basically within 10 days of when you knew or should have known of a protest. Typically, it's the award decision. For GAO, similarly with the pre-award protest, again, you have to file it prior to the solicitation due date, and otherwise it is the 10 days within they knew or should have known. There's an additional requirement or timeliness piece to GAO. They could also push it out later, that they get 10 days from their required debriefing. So if we have a required debriefing, they get 10 days from when it closes to also file a timely protest. One thing to note also with an agency protest or a GAO protest, if they file a pre-award protest, we have to basically issue a stay and not award the contract. In a post-award scenario, if they file a protest within 10 days of the award or within 5 days of a required debriefing with GAO, they also get a SECA stay, and we have to stop work in that case. The final piece is the Court of Federal Claims. There actually is no timeline, but they have to file within 6 years. That is the statute of limitations. However, you typically file early in those cases because they're after an injunction and stop work, similar to a GAO SECA stay. The first thing is determine if it's a timely protest, and then again if you have to have a SECA stay, because in that case you have to decide how long is my contract that's currently existing, and do I need to do a bridge, do I need to extend the current contract? Again, you don't want to break it in service, so that's your first piece. And then also think about your form with GAO. It's going to be 100 days and making sure that that contract can go out that time period. The next piece is making sure that the contracting officer and your evaluation team are available. Sometimes they've just been spending a couple of months doing an evaluation, and then, hey, I'm ready for leave or take some time off. And then we have a time period of 30 days, and so making sure that they're around to assist in getting that together. The other piece is getting the record together, and that is getting all the documents that we need for the protest and how we're going to defend it. That'll be the big piece. And the final piece there is the contracting officer statement of fact. That is truly the crucial document in any protest, and that is the piece that's really necessary to get started on and get that taken care of. So a contracting officer statement of fact, it's typically my tab 1 in a protest. But normally it's, if you think about it from the record standpoint, is all the other documents that have existed. The CO's statement of fact provides additional details that may not otherwise be in the record. It kind of pulls things and also is a way to pull the different parts of the documents together. Maybe you're talking about first about what happened in the solicitation, then what happened in the evaluation report, and so you're kind of putting it all into context, as well as explaining what the acquisition is to begin with. So once you get a protest, the agency has 30 days to put together an agency report. In the protest itself, they have a request for documents. And we get to decide first what is a relevant document. And so that would be the first piece that I would say there. We can object to certain documents or even portions of a document being included in the agency report. One thing I'll kind of also note that when you're talking about an agency report and what is submitted, typically there's a protective order and only the outside counsel get to see the documents. the protesters themselves do not get to see the documents, just to highlight there. But in the agency report, you think about, first we talked about the CO statement of fact, the memorandum of law, but then we'll also include a conformed solicitation. And so that's where we have if you had several amendments and had different versions of different attachments, it is the final version of each of those attachments. Any of the questions and answers that were part of the solicitation, the proposal of the awardee, or well, first the proposal of the protester, and then potentially the proposal of the awardee. I typically try to keep that redacted or out of the record. The source selection decision, any evaluation reports. I also include the notice of unsuccessful offeror and any debriefing that we gave. That's the typical documentation that is included in an agency report. So, and when you're dealing with a protest allegation, sometimes you read the protest and the CO is typically upset. Oh, what did they say this? I didn't do anything wrong. Then you kind of settle down and figure out what it is, and that typically what I tell the contracting officer and how we address those is, first, what is the allegation? What are they complaining about? I shouldn't have received a weakness. I shouldn't have received this deficiency. Well, then so we start with the allegation. The next I start with the solicitation. What does the solicitation say? That is for that technical requirement, what did they need to do? And then we typically next cite what did we say in the evaluation report. Actually quote the evaluation report saying, here's what we did. And this is where we talked about in the record in the CO statement of fact. This is where we can use the CO statement of fact to provide a little bit more context and detail that was not included in the evaluation report to help explain to GAO or others that are reviewing this on why these factors are considered and why something they didn't meet the mark in that regard. So with a GAO protest, GAO has 100 days total to make a decision. So whether you have once you have the agency report and then the protester has 10 days, if they file a supplemental, it doesn't add any more time to GAO's clock to complete their decision. I would note that's different than the Court of Federal Claims because they have no 100-day time clock, and it's whenever the court ultimately decides to issue that decision, which could take even years. Okay, so as far as in the GAO setting, basically we file the agency report. The protester gets 10 days to file its comments. They can also file any supplemental allegations, going back to that timeliness comment that you have 10 days from when you knew or should have known. So now that we've given the agency report, there may be some additional documents they received, and so they can file some supplemental protest allegations. If it's just comments, that's the end. There's nothing for the agency to do. Protester gets the last say. If there is a supplemental protest, then the GAO will set a new timeline for the agency to provide, whether it's an additional supplemental CO statement of fact, a supplemental memorandum of law, or if there's additional documents that we need to include based upon this new allegation. And sometimes maybe I had redacted things before, I'll unredact them in a document to better support the record based upon the new allegations. Again, once we do if we do a supplemental filing, then the protester gets 10 days to file any response to our comments, and at that point, the GAO would make a decision. One thing I would note that sometimes GAO will come back with some additional questions, or they may actually ask for a hearing to kind of help further develop the record. Those are very rare, but they do happen from time to time. So after the record is complete, GAO develops their decision, and they have their own internal staffing process. What they can do is at the end, they can publish or issue their decision. Typically it's filed on the EPDS, their electronic filing docketing system, and the parties get to look at it. At that point, we can look at whether or not there's any protected information in that document that we would not want to be released to the public. Once we get through that piece and everyone's in agreement, then they'll actually publish the formal decision. Instead of a decision, though, the other alternative for GAO is outcome prediction, and whether GAO does that sua sponte or if one of the parties asks for outcome prediction. It's kind of like alternative to dispute resolution, ADR. And they basically, it's kind of one-sided, I'll say this, in an outcome prediction. GAO has probably already written their decision and they're reading off to us, so we don't get to haggle over their decision. They're telling the parties, we get to ask some questions, but it's more of an interpretation of what they've said. Typically in that outcome prediction, you have the Air Force JACQ attorney, myself, and then I also make sure the contracting officers on that call just to make sure they understand and hear what the GAO is ruling upon. And again, if in that case, if they were going to deny the protest in an outcome prediction, The protester gets to decide whether they'll just withdraw the protest or if they want to go ahead and have an opinion published. In our case, if it's a sustain, then at that point the government has a decision of whether it wants to take corrective action or make GAO issue that public decision. So in my opinion, there are two ways to help avoid a protest. The first is documentation. We talked before as far as it has to be in the record for the GAO to make the decision. And up front, the very first thing I talked about was one of the things is an abuse of discretion. Were we unreasonable? One of the ways that we're not reasonable is we don't have the evidence in the record. What was the contemporaneous documentation at the time of the award decision? And one thing that I'll say is also with especially in technical, we have some technical experts that have a lot of knowledge on the subject, whether it's aircraft or RPAs or other things, and there's a lot that they know. If it's not in the documentation, and it's kind of an assumption or something they know, then it's hard to then have that documentation, and GAO would say, well, you didn't say that anywhere in the evaluation documents, and therefore it's an abuse of, the abuse of discretion, and they'll find prejudice in that regard and then potentially sustain the protest. So again, making sure that the documentation is clear, not that we need pages and paragraphs, it could sometimes as simple as a line or two of the analysis that makes it very clear and saves the document. The other piece I'll say is debriefings. Sometimes we want to do a written debriefing. Boom, here it is, done and over. Sometimes just giving them that opportunity to listen and even complain. A lot of times you'll have during debriefings, the companies will thank us for the debriefing. We do a pretty good job of our debriefings here at the AMIC. But also sometimes they just want to complain, or at least let someone make it feel that they're being heard. You're always going to have the protesters, some that will protest no matter what. It's like they're going to challenge it until the end. But again, I think that sometimes just being able to be heard will sometimes help prevent protest.